The government has introduced the Counter-Terrorism Legislation Amendment, Prohibited Hate Symbols and Other Measures Bill 2023. It has 5 schedules. The one making headlines is Schedule 1, which follows other Australian jurisdictions in prohibiting, amongst other things, the swastika. It is a difficult piece of legislation to interpret, so give me 10 minutes and I'll try my best to cover the big ticket item, the ban on displaying prohibited symbols. Also, I thought it might be a career-limiting move to do a YouTube video with a picture of me sitting under a swastika and Islamic State flag, so we're going to imagine that the Australian Broadcasting Corporation is actually an organisation similar to a white supremacist outfit. You know, imagine. At the outset, you'll need a little bit of background about Australia's federal structure. Australia has a Commonwealth Parliament, and each state has a parliament. Ignore the territories. At Federation, we enacted a constitution to create the Commonwealth. Around the world, there are various different models for federal structure. But here, our constitution says the Commonwealth has limited powers and the states have nearly unlimited powers. In practice, it is significantly more complex than this, and the Commonwealth's powers have expanded over the past century. But here's the important message to start our story. It is not obvious that the Commonwealth has the power to ban the swastika. What we will see is that the Commonwealth needed to be really clever about how it crafted the provisions, but this made it significantly more complex to interpret. Remember, the states definitely have the power to ban the swastika. This isn't an explainer about state laws, this is just a new Commonwealth bill that is not yet law. The big ticket items from Schedule 1 of the bill are 2 new offences: the display of prohibited symbols and the trade of prohibited symbols. This explainer will cover the first of these. Okay, so what is a prohibited symbol? The bill lists 3 symbols and then adds a category of symbols. The list is here. The Nazi Hakenkreuz, more commonly known as the swastika, the double Sigrun or Schutzstaffel insignia is less well known, and that lesser known aspect might factor into our thoughts in a moment. And the Islamic State flag, which the vast majority of you could not draw. And so the Act says these 3 things in these terms. This isn't me paraphrasing or being weird, this is the text. If it meets the description of one of these things, then it is a prohibited symbol. It then adds the next part to the definition of a prohibited symbol. Something that so nearly resembles a thing to which paragraph A, B, or C applies, that's the 3 things from the previous slide, that it is likely to be confused with or mistaken for that thing. This is the part that's causing some concern. As an early intuition, imagine that you wanted to ban the ABC logo. And everybody's like, yes, we know that image of white supremacy. All of us know what that logo means. But what would stop somebody from, say, making a version that looks like this? You don't want to have to update the legislation every time somebody gets into Adobe Photoshop and renders a slightly different variation of the logo. This part makes the net a little bit wider. But what is likely to be confused with or mistaken for that thing? The ABC logo is, in this case, like the swastika. We all know what it looks like and have some comfort that we would be able to spot something that was likely to be confused with or mistaken for it. But what about the double Sigrun? I'm not putting it up on the screen. I suspect that most people watching this video would need to go and Google it. As an analogy, it's a bit like this ABC logo. This was an early logo for ABC TV, but most people today wouldn't recognize it. I myself thought it looked a little bit like the Grundy TV logo. And this starts to show the issue. So it's not only this symbol which most of you do not recognize that is prohibited, but any symbol that could be reasonably confused with or mistaken for this symbol that you do not recognize is also prohibited. And this is a bit strange, because the more you know something, the less you confuse it or mistake it with something that is not it. A recent controversy arose involving Pink Floyd singer Roger Waters, who is very famously anti-war and anti-fascist. For decades, he has appeared on stage using imagery evocative of Nazism, specifically for the purpose of making anti-war and anti-fascist commentary. Recent controversy has resulted in media describing this as a Nazi-style uniform. Would the symbol that sort of looks like a swastika, but is clearly not supposed to be the swastika, get captured within the definition? Maybe. If it's likely to be confused with or mistaken for the swastika. As a matter of statutory interpretation, this is supposed to be read narrowly so that fewer things match the description. That is, it's not going to capture everything that is red, white, and black, where a fleeting view of it might cause the confusion. But it is open to a magistrate or judge to see Roger Waters' costume as fitting the description. The query would be how the judge or magistrate interpreted this provision. How narrowly would they read it? We would be surprised if a magistrate used what's known as the moron in a hurry test to establish if a symbol had been confused with or mistaken with a prohibited symbol. But I would want a higher threshold here. There is another escape clause for Roger Waters coming up, but I'd still prefer the higher threshold in the definition. But this is where it gets especially bad and starts to spell a bit of racism when we get to the banning of the Islamic State flag. Again, not putting it on the screen, but the Islamic State flag is white Arabic text on a black background. The text is known as the Shahada, and I'll put a link in the video description to a piece from Dr. Rayhan Ismail that explains the religious significance of the text. The text itself is on Islamic buildings and integrated into architecture, completely unrelated to the Islamic State. So what could be confused for the Shahada in white text on a black background? Well, it turns out that any Arabic text in white on a black background will reasonably be confused with the Islamic State flag. The first draft of this video had greetings from Agrabah, the fictional state in Disney's Aladdin in Arabic text to illustrate the point, but refer to my earlier comment about career-limiting moves. Weirdly, writing it in English would appear to be completely fine. White Arabic text on a black background, no matter how innocuous, potentially a prohibited image. So we know what a prohibited symbol is. You cannot display a prohibited or trade in a good depicting a prohibited symbol. And here is the first part of the offence to display a prohibited symbol. This slide is deceiving you into thinking that this is straightforward, because if it was just this, it would be unlikely to be constitutionally valid. Hold on tight. Our enemy today is Section 51 of the Australian Constitution, which outlines the topics on which the Commonwealth Parliament can legislate. Whenever the Commonwealth Parliament makes legislation, it needs to find what's known as a head of power that authorises the legislation. This does not apply to state parliaments. With a few exceptions, the states can legislate on anything and everything. So we saw earlier that Victoria has passed legislation to ban the swastika. It could do that because there was nothing stopping it from legislating. The Commonwealth, on the other hand, needs to find a head of power, and this causes a problem. There is no obvious head of power for the Commonwealth to ban the swastika. How do you get around this? The answer, sticky tape. You say, I've got all these heads of power. Can I find some way to attach my ban of the swastika to one of those heads of power? And the answer is absolutely yes. For the display provision, you just need to get a little bit creative. So let's look at the new offence of displaying a prohibited symbol. A person commits an offence if the person causes a thing to be displayed in a public place and the thing is a prohibited symbol. If it was just that, it is likely that the offence would be beyond the legislative competence of the Commonwealth. And so we add an extra provision to make it constitutionally valid, and it will blow your mind. Here we go. Prepare your mind. Are you ready? Next slide. Subsection 3, 4, or 7 applies. Oh yeah, constitutional catastrophe averted. I'm sure you were relieved. Or at least you would be if you knew what sections 3, 4, and 7 are. As a very quick, imprecise, and technically inaccurate shorthand, you can read this provision as, and it relates to the treaty's power. Specifically, the International Convention on the Elimination of All Forms of Racial Discrimination and the International Covenant on Civil and Political Rights. The treaty's power is shorthand really for two different powers. We are only going to deal with one of them, the ability to create legislation that gives effect to treaties. The other power is the executive's power. That is, the power of the Commonwealth government to enter into treaties. We'll ignore that power and focus on the ability to create legislation that relates to treaties. Trick or Treaty was, I kid you not, the name of the 1995 Senate inquiry report into the nature of the treaty's power. Section 5129 is the head of power for the Commonwealth to legislate on matters related to external affairs. Over a series of cases, the High Court has interpreted this as giving the Commonwealth the legislative ability to put our treaty obligations into effect. There is no head of power for the Commonwealth to protect the environment. But if we entered into a treaty to protect the world's cultural and natural heritage, for example, then the Commonwealth would be able to enact, say, a World Heritage Properties Conservation Act, even though there is no other head of power to enact legislation to protect the environment. In the 1960s, Australia became a party to the International Convention on the Elimination of All Forms of Racial Discrimination and the International Covenant on Civil and Political Rights. And it's these treaties that provide the hook for the external affairs power. And that's what sections 3, 4, and 7 plug into, subsections 3, 4, and 7. In brutally simplified terms, subsection 3 says that it is an offence to display the prohibited symbol in public if a reasonable person would consider the display as involving dissemination of ideas based on racial hatred and racial superiority. It also says it's an offence to display the prohibited symbol if it could incite another person to offend, insult, humiliate, or intimidate people based on their race. This meshes up with Article 4 of the Convention on Racial Discrimination. Subsection 4, in similarly simplified terms, does a similar thing, but this time the focus is on advocacy. It is an offence to display the prohibited symbol if a reasonable person would consider that the display involves advocacy of hatred towards a group based on their race, religion, or nationality, so wider than just race. It is also an offence if the reasonable person would consider it advocacy that constitutes incitement of another person to offend, insult, humiliate, intimidate, or use force or violence against others based on race, religion, or nationality. Now, I think there's a typo in the bill, and there was supposed to be an explanation of what the Covenant is, but it's pretty clear that it's Article 20 of the Covenant on Civil and Political Rights. Subsection 7 is also, if we agree with my reading of the missing definition, aligned with the Covenant on Civil and Political Rights, this time Article 26. It's an offence to display the prohibited symbol if it is likely to offend, insult, humiliate, or intimidate a person based on the basis of their race, colour, sex, language, religion, political or other opinion, or national or social origin. People showing up with swastikas to offend the trans community, as we saw in Melbourne, would likely be pinged under this provision. Now, you might recognise the language of offend, insult, humiliate, or intimidate. It's from Section 18C of the Racial Discrimination Act 1975, the provision that upset a lot of Australia's media when it pinged Andrew Bolt back in 2011. The argument is that offend, insult, and humiliate is too low a threshold, and I strongly disagree with those people. But back to the offence. There is a carve-out, and then there are defences. First, the carve-out. The offence does not apply when you're displaying a prohibited symbol for religious, academic, educational, artistic, literary, or scientific purposes, and the purpose is not contrary to public interest. There is my beloved public interest test, which some of you might remember from my favourite version of the justification defence in defamation law. Here you can clearly see why it's needed. If I'm waving around a prohibited symbol in a way that is clearly designed to intimidate minorities, I shouldn't be able to say, oh, this is for science, or this is art. Roger Waters would be able to claim that his performance of the wall meets this carve-out, probably. The offence also does not apply if you're a journalist making a news report or current affairs report that is in the public interest. That last bit is interesting. By a person working in a professional capacity as a journalist. This would stop you from having a little hate parade in the middle of Melbourne and organising one of your mates to film it and live stream it to the internet under this carve-out. The query here would be who gets the protection. It's obvious for mainstream news outlets, but what about those weird little websites that purport to be news outlets? The problem with the carve-outs is the capturing of the Islamic flag within the definition of a prohibited symbol, especially when white Arabic text on a black background can be confused with or mistaken for the Islamic flag. The problem I see here is the 17-year-old hothead who is particularly passionate about Israel tripping into these offences at a protest. Maybe they write about Palestinian rights in white Arabic text on black background. The protester is trying to be provocative, maybe even offensive. But there is no carve-out, and at this point you are skirting pretty close to subsections 3, 4 and 7, depending on the temperament of the police arresting you and the magistrate hearing your case. If I were drafting this, I would drop the Islamic flag and make it clearly about Nazi imagery, and even then, think about carve-out for genuine protest. Defences are where the elements of the offence have been established, but you have some good reason to have committed the offence. Here they are overwhelmingly technical and boring, and almost entirely seem to be about undercover cops. That is true. The ones that are interesting for us are displaying the Islamic flag or something resembling the Islamic flag for the purpose of opposing global jihadist ideology or related ideology, and displaying the Nazi Hakenkreuz or Doppelsieg or something resembling those for the purpose of opposing Nazi ideology, fascism or related ideology. It is not a general defence for protest though, so our 17-year-old hothead who was passionate about Israel would be unlikely to be covered here. And while researching this, I looked at some photographs of protests, and there are swastikas and signs in Arabic that, in my view, might not be protected. So there's the new offence. Mark opinion time. I am very much in favour of banning the swastika. I am very strongly of the view that if you want to display it, you need a good justification for it. I'm less thrilled by including the Islamic flag within the scope, especially given that it ends up including any white Arabic text on black background, potentially. I have some concerns about its application to protests. On the one hand, you probably want the protest provision to be a bit broader than it is here, but not so broad that, for example, an anti-trans rally or anti-immigration parade could adopt the Nazi imagery. Happy to take questions to discuss this further. There we are. If you want to continue this argument, legal reckoning, on Twitter, like and subscribe, and I will see you next time. Bye-bye.